Hi Raymond, how was your flight? Meh. Raymond has joined us from Durban. Okay, let's find you. Right, so Raymond Meneses has a deep theoretical and practical understanding of all facets of employment law, backed up by a quarter of a century of experience in that field. He's a skilled litigator of employment disputes and a seasoned negotiator in resolving such disputes. Being solution-driven, Raymond always seeks the most cost-effective and expeditious resolution to any employment challenge or conflict. So although I'm going to stop there with the blurb, because basically Raymond is the labor guy, and he's about people. And although a lot of that is about disputes and all of that, today we're going to go back to the beginning of the story with regards to employment, where to start and what some of the definitions are. And we're going to very specifically talk about remuneration factors. Okay, Raymond, hello, welcome. Who are you and what do you do?
I'm an employment lawyer, so I help typically employers, sometimes employees, in anything to do with employment law. I have a particular interest in how employment law intersects with the medical profession.
My slides here are just to guide some of the questions, and we'll stop in between and ask questions. So with regards to South African labor law, or South African law, and the HPCSA, because now those are two fields that we don't quite know how to navigate, can you help us understand the difference between a locum, a contractor, an independent contractor, a consultant, and an employee in the spaces of medical practice?
Okay, so a locum may be, a locum may be an independent contractor or an employee, and an independent contractor may be a consultant. So the way that these terms are used by lay people or by employers is sometimes confusing. So I'm just going to go through some of the basic concepts. A locum is somebody who fills a space in a medical practice on a temporary basis. That person could be an employee in terms of a fixed term contract of employment, or could be an independent contractor, sometimes called consultants. It's the same thing typically, who is not an employee, but is rather somebody who is responsible for their own tax and their own, the running of their own affairs. They're not employees. So the primary consideration for who is an employee, and there are different tests which apply, is somebody who earns remuneration, so earns wages, or a salary, or some other form of financial benefit, and who is therefore covered by the Basic Conditions of Employment Act and the Labour Relations Act. People who are not employees are not covered by the Basic Conditions of Employment Act and the Labour Relations Act. I'll talk a little bit about Basic Conditions of Employment Act a bit later.
And how does the HPCSA see the differences between some of these things?
So it's not something that the HPCSA has specifically addressed. HPCSA is obviously conversant with concepts like locums, but there's no prescription, if you'll pardon the expression, as far as whether a locum has to be an employee, either a permanent employee, typically not a permanent employee because locum is by its nature temporary arrangement, and or an independent contractor. So they would be either a fixed-term employee or an independent contractor.
Let's see what's next on my list. I think, although the definitions are a little bit confusing, what's really important is how the relationships are structured. So Raymond, tell us, why are contracts important for both parties, employer and employee, locum and practice owner, whatever it may be? Why is the contracting important?
Okay.
5 minutes, please.
It's that time of the day where I want to start nodding off. So I'm gonna engage with you a little bit before giving you dry definitions. Who here is married? Raise your hand. Or have been married? Those are the guys I should be talking to. Or who here has a significant relationship, either a romantic partner, or children, or parents? Yeah, right. Everybody's got parents, right? Okay. I want you to think about the one thing, every single conflict you've had with that significant relationship has been about. It's only ever been about one thing. What was it? Money. You know, I tell you what, married people, I ask this question all the time. Married people give me three things. Say it's about money, sex, and children, not necessarily in that order, right? But that's actually not what you're fighting about. You're fighting about something else. What else is it? Sorry? Misunderstanding of what? Communication of what? You're right. Interference with what? You're right. The in-laws. Listen, that's a big deal. But it's those are symptoms. I couldn't agree with you more. But those are symptoms. You're actually fighting about something else. Expectation. You know how rare it is that I get that as a correct answer. Every conflict you've ever had with somebody who's in an important relationship with you has been about an unmet expectation. You expected A and got B, or somebody expected A and got B from you. Every conflict is about an unmet expectation. You think about your interaction with your kids, you expect them to do what you ask them to do, right? And they don't. They expect you to be an ATM. Right?
Yes.
Yeah. So conflicts are about expectations. Why do you think we regularly have conflicts about expectations?
She mentioned it. He mentioned it. Communication?
Because we're terrible at communicating what our expectations are. Yeah? And we're particularly terrible about communicating what our expectations are because we don't know what our expectations are until they're not met. How many of you have had this exact conversation? And I expect honesty here. Spouse A says to spouse B, "Why didn't you do X? I didn't know that you wanted me to do X. You never asked me to do X. I shouldn't have to." Right? You've had this conversation?
Yes.
Yeah. What do you mean, I shouldn't have to? You should know.
Yes.
Right? And there's a gender divide on that, but in general terms. And then you have a fight. But really, what's at the heart of that conflict is there has been an inaccurate, typically on the one side, communication of an expectation, or very frequently on the other side of that equation, a poor reception of the communication. Now what happens, and I'm talking to medical people so you'll know exactly what I'm talking about, when you're in conflict, how well does your prefrontal cortex work?
Not well.
Not well, it shuts down. Your amygdala fires up, your sympathetic system gets on its horse, and you start communicating the way cavemen do.
Fight or flight.
Yeah, fight or flight, or freeze or fawn. Yeah. So that's a terrible space to engage with expectations. Now, why is this relevant? A contract is no more and no less than an accurate record of expectations and the consequences of failing to meet those expectations. That's all it is. Every law in every country is a written record of the expectations of the state and the consequences of failing to meet those expectations. So once we start thinking of it in those terms, instead of thinking of it in terms of it being complex, it's much easier to navigate what the appropriate instrument is, the contract, to record those expectations. So for an employee, the law says, the Basic Conditions of Employment Act says, that the particulars of employment should be recorded in writing. What does that mean? It doesn't have to be signed, by the way, although it's a good idea. It means that the function is written down. It means that the remuneration, what the person's going to get paid, is written down. And the hours that they work is written down. people get all bent out of shape and say, well, I'm not prepared to do something that isn't written in my contract of employment. That's not the requirement at all, because contracts shift and functions shift, and it's impossible to anticipate every eventuality. So that's just a stupid argument. But at its base, a contract should record accurately what both parties' expectations are in broad terms, and the balance is then fleshed out as the relationship develops.
Got it? Okay.
Make sense? Keep it simple.
That's my question, is employment contracts are typically quite long and wordy and legalese and all sorts of things. And I've had this in my own practice where I've had to go word for word through an employment contract with a young 20-year-old who doesn't know anything.
Yeah.
How simple can we make these documents?
Simple. So I was exposed many years ago to a group that had developed in the United States, funded by the federal government back in the day when they made some sense, which was the plain language movement. And it was aimed at getting lawyers to write and speak in language that people could understand.
Nice.
And what happened is that professors from the top universities, Harvard, Yale, came together and said, how do we get lawyers to write and speak in English in a way that people can understand it, so that contracts are not a barrier to understanding, but they are rather an aid to understanding. Expectations. And they came up with a whole lot of strategies to get communication very simple and clear. And I listened to a few of those lecturers speak on the subject, and I made it my goal from then, it was well over 10 years ago, to write and speak in a way that people could understand.
Nice.
And my experience is that if you write contracts clearly and simply, you have less conflict, because there's less misunderstanding. So what happens is, when we have a conflict, we think in terms of morality. I'm right, you're wrong. Someone is to blame. Most conflicts are not moral. Most conflicts are about a failure of expectation, which is not necessarily moral. Sometimes, but typically not. It's just an expectation that isn't met. So once you take away the sting of imposing moral blame when there's a failure of expectation, we take a lot of the heat out of the conflict, and it's easier to resolve. So that sounds airy-fairy, but it's very simple. Contracts should be very simple, very clear, written in everyday language. Unfortunately, most precedents that people work from were written 20 or 30 years ago in highly complex language. It's not necessary. It can be very simple. Be careful using AI. I personally hate AI with a holy passion, because it's training us to be stupid, and it's a form of plagiarism. So I loathe it, but it can be useful. And I have friends who use AI for contracts. It shouldn't be their only port of call. But one of the advantages of using those systems is typically the language is quite simple. I don't like AI. I'm happy to have a debate with anybody about that. I think it's awful. But it is more and more in my practice, I'm seeing people who've used AI and not used the right prompts, and it's wrong. It's just wrong. I've had colleagues give me legal opinions that were used using AI, and stuff is made up in there. It's just not based in law. So it's not a good idea to check your brain out at the door. But what I am saying is, if you are going to use a precedent of any description, it's better to get it from somebody who can read and write in a way that's clear and easy to understand.
And I'm going to jump to the third point here. What would you say are some, actually you've mentioned some of them, purpose, function?
Yeah, what's the role? What are they
Remuneration,
expecting
hours.
to do? Hours and
Okay.
money, yeah.
So what if we're in a situation where someone is providing services for whatever that is, and there is no actual written contract? Where does the basic conditions of employment come in? And if there is a contract, which one supersedes the other?
Okay. The Basic Conditions of Employment Act is the bare minimum which an employer has to provide to any employee, irrespective of whether there's a written contract.
Okay.
So the Basic Conditions of Employment Act will always trump Always. You can't contract out of the provisions of the Basic Conditions of Employment Act.
So if
It's
there's
the
something
bare
dodgy
minimum.
in your contract, it will
The
default.
BCA will always be the default, yeah.
And what are some of those dodgy things that you've seen happen in your practice that the BCA trumps?
Okay, so for example, I'll give you a recent example because there's been a development in terms of the Basic Conditions of Employment Act, which most employers are not aware of. We have, in South Africa for many years, had maternity leave, which is 4 months unpaid, unless the employer chooses to pay, 4 months unpaid maternity leave, right? Everyone's familiar with that. In the last couple of years, that has changed. We now have parental leave. Parental leave means that and I'm going to use this term loosely, the parents, and I say loosely because it covers adoption, surrogacy, homosexual relationships, married relationships, customary relationships, customary unions, and formally married people by civil union. The one parent and the other parent, who may be employed by different employers, have to reach agreement on who is going to take the parental leave and for how long. So the mother would take a minimum of 6 weeks of the 4 months, but the balance of the parental leave may be taken by the father or the partner. I say father, it might not be a father. And there are other qualifications as well. There's a minimum of 10 days that has to be taken. It's more complicated. But the vast majority of employment contracts that I've seen don't have those clauses.
Or haven't been updated since.
They haven't been updated. So there was a change to the Basic Conditions of Employment Act in relation to parental leave. There was then a judgment that said, wait, the BCA doesn't go far enough. That was changed. That judgment was challenged, went to the Constitutional Court. Constitutional Court said the court below didn't go far enough. We're making it go even further, and has given the legislature, so the drafters of legislation, time, 2 years I think, to revise the Basic Conditions of the Employment Act to bring it into line with what the Constitutional Court has said. So it's in a state of a little bit of flux. I'd be surprised if the legislature said anything other than what the Constitutional Court said was the minimum. But that's an example of where the employment contracts that most of you have will not reflect the reality of the legal position.
Okay, let's just check in here. How many of you have employees within your practice? I don't. Okay, a couple of you. How many of you are employed or work for others? Okay. For those of you who have your own employees, how many of those employees are clinical? How many of them are admin? Or both, you know? Okay, cool. Just checking in. Right. Yesterday we chatted to George a little bit about personal income tax and VAT. So you have an understanding of what those are. There's a couple of other acronyms that come up when you are an employer that you also need to understand as an employee. And when I was employing for the first time, these were the sneaky costs that I had no idea came with being an employer. Raymond, income tax and VAT we'll get to a little bit later, but run us through some of these costs. I've got a nice diagram just now about who pays what, but let's just understand what these are first.
Okay. So in terms of the Income Tax Act, employers are obligated as agents on behalf of SARS to deduct certain amounts for tax. And that includes statutory deductions such as UIF, which is Unemployment Insurance Fund. It's worked out on a percentage. Skills Development Levy, which is, I think, 1% for every rand that's earned as remuneration. And that only applies if the employer makes 500,000 rand per annum, a minimum of 500,000 rand per annum. As soon as you make 500,000 rand per annum, then the Skills Development Levy kicks in. COIDA, Compensation for Occupational Injuries and Diseases Act, that's a compulsory deduction for employers to cover injuries on duty. I mean, you're medical people, you know what COIDA is. So those are all amounts which are statutory, and they're deductions which have to be made in terms of legislation dealing with the recovery of tax or forms of tax, statutory deductions, to cover employee benefits, such as UIF and compensation for occupational injuries and diseases.
We'll get into some questions about this just now, but let's clarify where VAT sits into this. There was a question on the Private Practice Growth Club Facebook page saying, well, you know, why is my commission, she was a percentage-based earner, or I presume a locum, why is my salary, why is this VAT number, like where does VAT fit in for commission-based earners?
Okay. The primary distinction is if you are an employee, you pay PAYE tax. So PAYE is pay as you earn. So whatever you earn as remuneration is taxable. If you're not an employee, so you're an independent contractor and you generate income not as remuneration, but as some other form of income, fees. So that's the distinction. Are you an employee or not? If you're an employee, tax, a PAYE. If you are not an employee, then that becomes relevant. If you earn more than more than R1 million a year, you're obliged to register for tax, for VAT.
2.3.
But it's about to become 2.3 from the 1st of April. We're not there yet, baby.
Ah.
Not there yet. 1st of April. 1st of April. So that's the change that's going to come about. It's only relevant if you are not an employee.
Okay. Does anyone want to jump in with questions now? Okay, let's hold that thought. I want to show you my cool slide. Who pays what? Okay. So here we sit with the employer on one side, our employee on the other side. How I understand this is that the employer pays certain things all the time. UIF, SDL, COIDA, and VAT. Am I correct in that understanding?
Yes.
But
You know what? If lawyers had a rallying cry, if we had a T-shirt that lawyers were obliged to wear, it would say 2 words. It depends.
fair enough.
Yeah,
Well,
because employers may be required to withhold PAYE for independent contractors in certain circumstances.
okay.
So it's a flat rate of, I think, 25% for independent contractors, subject to certain parameters. But if an independent contractor is regularly receiving amounts from a single source, so you've got a consultant, independent contractor who works for the same entity and gets paid 40 grand a month consistently, then I can't remember, it's 27 or 25%. There's a distinction between personal service provider companies and independent contractors. But there's an obligation to withhold tax, PAYE, even though technically they're not employees, they're independent contractors.
Okay.
And that has its genesis in the fact that independent contractors were originally devised or used by many as a way of getting around paying tax. Somebody calling me? No.
No.
And SARS, because SARS likes money and likes taking it from us, said, well, even if you are an independent contractor, if you're regularly getting money from the same source, we'll deal with it later, but you've got to deduct a certain amount for tax. And SARS has become slightly more sophisticated when it comes to that. They now distinguish between personal service provision companies, so it could be a trust, could be a CC or a PTY Limited. If that personal service provider has less than 3 permanent employees who are not shareholders or membership interest holders in a business, and earn more than 80% of their income from one client, then they're regarded as a personal service provider and different tax considerations apply. So in a perfect world, an independent contractor is completely responsible for their own tax, and issues like VAT and company tax on profit are the only considerations. But because that's been used as a vehicle to bypass the protections and to bypass tax, the receiver does apply recovery methods to get some tax back. So I say when you're a medical provider and you own your own practice, it's a really good idea to get a specialist bookkeeper or accountant who's familiar with tax and maximizing tax avoidance, not evasion, to have a look at this and structure it in such a way that you can get the maximum benefit when it comes to not paying the receiver any more than you absolutely have to.
Okay, that makes sense. Does anyone want to jump in at this point? I want you to start thinking about your own employees and contracting systems. Maybe we'll finish our slides and then we'll get into some real life stuff with your questions.
Yeah, let me give you an example. I had a client last week contact me and say, we've got an independent contractor who we've been paying as an independent contractor and deducting a flat 25% for many years. 27%. No, 25% for many, many years. There's never been an issue. But SARS has now said to us, hey, why aren't you deducting 27%? There's a distinction. Isn't that a personal service provider? And the individual who's been the independent contractor, it's in a tertiary education context, said, no, I have 3 employees. I don't only get 80% of my income. I get income from other sources. I insist on you paying me the preferential tax rate. And my client came to me and said, what do I do? I said, it's very simple. We can have an argument with them, or you can say to him, you approach SARS and get a tax directive. It's not my problem. I'm acting as an agent for SARS. I'll do what SARS tells me to do. I don't want to fight with the individual or the independent contractor or the personal service provider. Let them go and do the homework with SARS. So if you have somebody who's an independent contractor and you are paying them on a monthly basis, get them to go and get a tax directive from SARS so that they can do the running and the paperwork, and you just deduct the correct amount, because you don't want SARS to conduct an audit on you because they're suspicious of the amount that you're paying to a third party.
That story is interesting because George told me something similar about one of his clients, the accountant, that SARS came to them as the accountant saying, your client as the employer is not paying enough tax for the staff member who is receiving income from other sources and not paying the difference. So these things get quite messy, and the employee isn't always aware of what they need to do independent of that contract.
Yeah, not an employee there, but the service provider, the consultant.
Okay, let's talk a little bit about commission remuneration, because I think this is really important in healthcare and small businesses. We want to pay people by commission because cash flow is always a bit of an issue. The HPCSA says some things. It's a bit of a hot topic at the moment because we're not actually sure if we're allowed to. So where does commission, and okay, VAT I think we can cross off the list, but what is the law around paying commission-based salaries?
It's not at all unusual for professionals to get paid commission exclusively. In fact, it's kind of a norm. It's also not unusual for one professional to perform services for several different practices and to earn commission from more than one practice. So it really depends on the facts of each individual case. I have no difficulty in principle with paying exclusively commission, but your bookkeeping must be accurate and your timekeeping must be accurate, and you must be in a position to be able to justify to the receiver and anybody else if there becomes a dispute with the service provider that the contractual regime is in place. You've got a written record of how this has worked out, that the record keeping, if it's on a basis other than time, so if you're getting a percentage of the fees generated for the consult, whether it's on fees paid and recovered, if it's on fees billed, what does that look like? How do you deal with the fact that sometimes medical aid doesn't cover stuff? What's the arrangement? So I say you should have an accurate record so expectations are clear right up front. This is how we bill. This is what happens if medical aid doesn't cover it. This is what happens if there's a comeback, a clawback. This is how we deal with it. This is the timing of it. If we bill in month 1 and we only get paid in month 2, well, how long after getting paid do you have to pay the commission over? These are things that, I mean, you'll have a practice, but it's really important to record that so that we don't have a drama later.
And what exactly does the HPCSA have to say about this? Because where does it fall in with things like perverse incentive and overbilling so that you get a little bit more commission?
The HPCSA gets grumpy when you're playing fast and loose. I think if you have an accurate record, both in terms of the contract and in terms of how you've applied the contract, and you can demonstrate that we've been consistent, nobody's pulling a fast one here, then the HPCSA is going to say, all right, as long as there's nothing unethical happening, we're happy.
Have you dealt with any cases like that?
No, not as yet. I have had some issues where I had a multidisciplinary practice that was billing under the PCNS number, the registration number, of a medical practitioner who left the practice, and they didn't change the details. And there was, I think, 4 million rand had been billed through the incorrect number, and the medical aid said, well, we regard that as an improper billing. You need to pay that 4 million rand back to us, even though those patients all received the services, they received the treatment. And there was then litigation about whether that was regarded as improper billing, an improper billing practice. And the argument was, look, there may have been an administrative error, and it was genuinely an administrative error. There was an admin person who didn't do the right thing. But it wasn't dishonest. But strictly speaking, in terms of the regulations, you may not bill under someone else's number. So it got ticklish. So really, again, expectations. You've got to line up what your contract says with what you actually did, and you've got to be able to follow the money to demonstrate that there was nothing unethical.
Okay, contract. Write it down. What happens when things change? So when a practice or an employee, whatever, the people involved want to go from part-time or full-time or back, or commission to salary and back, I presume your answer is going to be contract, but how do you manage changes and have to write them down?
Okay. I teach people how to have difficult conversations. Because we, as professionals, and I include lawyers in this, we're trained on everything but the most important part of your job, which is how to have difficult conversations. As a medical practitioner, you will have given a patient bad news, and that, or a patient's family bad news about somebody dying. And it's really, really difficult to have that conversation if you don't have a framework in your own mind about how you're going to approach it. So when you're engaging with another party in regard to either setting up a contract or changing the terms of a contract, there are 3 things that you need to have in mind at all times. They're going to be thinking about reputation. How does this affect my dignity? They're going to be thinking about money. How does this affect my pocket? And they're going to be thinking about longevity. How does this affect my employability or my capacity to earn income into the future? If you can say at the beginning of the conversation, we're going to be talking about money. Money is always difficult. And your ability to generate money. That's always a ticklish conversation. Why? Because who we are, our identity is tied up with how we earn our money. How do I know that? if you meet somebody for the first time, what's the first thing they ask you? What do you do? Because how you earn an income is going to have a bearing on how I'm going to treat you, which is terrible. We should never ask that question, right? You're actually negotiating up front. How much respect am I going to give you? When it comes to lawyers, very little, but it's just an interesting aspect of the human dynamic. So you will perhaps know as medical specialists that your psyche, your brain, is incapable of determining the distinction between a threat to your dignity and the threat to your physical integrity. So an email which makes you feel like you're being disrespected is dealt with in your brain chemistry the same as if you had a great white shark swimming at you with its mouth open going like this. Your brain can't tell the difference. All of your chemical responses, your electrochemical responses to that are the same. So what you want to do if you're going to have a difficult conversation is you want to front load the message by saying, I've anticipated that this is going to be a hard conversation because we're going to talk about your dignity, your reputation. We're going to talk about your bucks, your money, and your employability or your capacity to generate income into the future. And I've anticipated the best way I think we can address each of those fears. And I'd like to propose that we address it in these ways. Now, immediately the person's thinking, oh, they've seen me, they've heard me, they know what I'm going to be worried about, and I don't have to defend myself. It's immediately an easier conversation. About twice a month, I terminate somebody's employment relationship in an organization. I have a negotiation with them to exit them from a business. That's the worst, one of the worst conversations you can have. I've had people thank me. Why? Because I've anticipated their fears. And I've said, this is how we would like to address those fears in a way that protects your dignity and your money and your capacity to generate income into the future. And if you can do that well, then the contract becomes simply an accurate record of what you've agreed. That's how you do it.
And would you draw up a new contract?
You can draw up a new contract, or you can draw up an addendum to an existing contract.
Okay.
And it can be very simple. Simpler is better.
Always.
Always.
Is that a bit of a relief to know that your contracts can be simplified and really should be simplified for you and your employees?
So I train young lawyers for my many sins, which are multiplying, on how to draft contracts and how to deal with humans. And one of the things I drill into them is, if you can't explain it to a 6-year-old, you don't understand it yourself. When you're negotiating a contract, you've got to be able to explain it to a 6-year-old. What am I going to pay you? What are you going to do? And what happens if you don't do it well?
So let's talk about that last point. You've employed someone, things are not going well, and from you as the employer, you've decided it's best for the practice and for you, for this person to leave. I know it depends on what's going on. How do we manage disciplinary action and yucky stuff?
Okay.
Because I know this is your forte.
Yeah, first of all, I'm going to borrow from the King James Authorized Version of the Bible. Gird your loins. Gird your loins. What do I mean? I mean, harden up. Say, I'm going to have a difficult conversation. You know what? It's okay. I'm not going to die, and they're not going to die. We're going to have a difficult conversation. The primary difficulty I have representing employers is that people in positions of leadership are too scared to have difficult conversations. Just decide, I'm going to have that hard conversation. And I'm going to be kind. I'm going to be kind about it. Even if you're exiting them, you're going to be kind. So, as an employer, you need to know the difference between discipline and performance management. They're two different things. Discipline is the employee did something wrong. Performance management is I've employed somebody who can't do what I need them to do. One is fault, one is no fault. Discipline is could have, should have, didn't. See, I'm explaining to a 6-year-old. Performance is should have, couldn't didn't. Performance, you fix the couldn't with training and counseling. And if training and counseling doesn't work, you terminate, not because it's their fault, but because you hired the wrong person. Discipline is different. Discipline should have, could have, didn't. It's wrong that they didn't because they could have. Their guidance, counseling, maybe training, but we hold a disciplinary inquiry. Maybe there are warnings, maybe there aren't, depends how serious it is. And you terminate because that person didn't do what they should have done even though they could. It's a different approach. So if this is how I explain performance. If you hired me to be a ballet dancer, my brother's a professional ballet dancer. You hired me to be a ballet dancer, you can guide and counsel me until you die. Never going to happen. But you see me in tights, run. There's something unholy and unnatural happening. It's just never going to happen. Because the person who hired me as a ballet dancer hired the wrong person. I'm not that guy. You hire my brother as a lawyer, you've made a mistake. Great dancer, not the best in an argument. Performance is about hiring the right person. It's about recruitment, and it's about training and guidance. That's all it is. If you know somebody can do it and they're not doing it, it's probably a discipline issue. If it's not a discipline issue, it might be that there's a health issue, there's a depression issue, there's some other form of incapacity that's happening in the background, they're getting divorced, something difficult is happening. Have the conversation, figure it out, and see if it can be fixed. If it can't be fixed, you're not obliged to keep somebody who can't do the job. It's not personal, but it's always personal.
Do you find that employers, particularly in our field of medical, struggle with discipline, performance, mentoring, or whatever, but specifically the discipline part?
Yes, because healers are kind. Typically, there are exceptions. But healers are kind. So you want to make it work. And what medical people typically do, there are exceptions. You get Nazis, right? I've seen medical practitioners who become autocrats, especially in hospital settings. I'm like, see, I'm getting some knowing nods here. People who've worked for the state. And you're like, how did you get here? I don't know, man. Something went wrong. They should have studied dentistry or something. I don't know. They enjoy inflicting pain. No, I'm kidding. I love dentists. Far away from me. Typically, medical practitioners are kind. So they will tolerate and accommodate until it reaches a point where you can't. And then both of you are no longer in the thinking phase. You're in the fight, flight, freeze, fawn phase. And somebody's going to suffer. So it really means that you want to deal with problems early. I always build a probation clause into employment contracts, and probation is an opportunity for employers to deal with failure of performance early. Guide, counsel, address problems, revisit expectations, speak about what needs to be done to meet those expectations, and if they're not meeting it, hold the performance hearing in the probationary period and terminate their services. You know what? The CCMA very rarely interferes with a probationary dismissal. If you let them survive beyond probation, you then have to jump through a few more hoops. Not impossible, but it's better to deal with it early. You're medical people, so I'm going to speak to you in medical terms. The earlier you intervene in a medical situation where you've identified a problem, the more conservatively and easier you can deal with the situation. If you pick it up too late, you have to have more and more radical interventions. Just deal with it early, right? And be kind. Honestly, kindness makes it better.
Absolutely. Yeah. I've had to have a number of difficult conversations, and it's nerve-wracking as hell, but the kindness definitely makes it go smoother.
Yeah.
I had a question, but it's gone. Maybe I'm going into early menopause. Right. Have you got some questions for Raymond?
Yeah. Thank you very much for the presentation. There's something I'd like to know.
Can't hear you, Bat.
Okay, a foreign trained doctor with limited registration with the HPCSA, that is someone without independent license.
I'm so sorry, I'm struggling to hear you. Just lift it up a little bit.
Okay, sorry. A foreign trained doctor.
Foreign trained doctor, right?
A foreign trained doctor.
Right.
With a limited registration with HPCSA. That is somebody without a full registration or independent license. Are they allowed to do locum in private practice?
I don't think so. I don't know specifically, but I think you have to be registered and you have to have the registration number. I've forgotten the name of it.
HPCSA
HPCSA number, yeah, to practice. So if you have registration, you're fine. But I'm not sure what that story is. I don't know.
Who wants to fill in?
A foreign trained doctor with limited registration cannot do outside work because if you do locum work, you need to have your MPS has to be, your indemnity insurance has to be right,
Yeah.
and all those things also. And also the HPCs, can come after you and say you're not allowed to because you can't do that. You can't do locums if you can only work in government.
Thank you. That's what I thought. Right, you expressed it so well.
Yeah,
Thank you.
it also, remember, if you're foreign qualified and you're employed in hospital, your registration limits you to public service. And for you to be able to do locums or to work in private, you then should be registered in independent practice. So if you are in a hospital, it can only be public service. And if it's public service, you can't do locum.
So for those of you employing foreign qualified, you also need to know that. Okay, I didn't know that. Right, anyone dealing with uncomfortable situations in their practice?
Yeah. Thanks for the presentation. And this is a problem usually for us black practitioners. You employ somebody who is not a professional, and especially if it's your hometown, and he or she works for you for, say, 30 years. And then when they retire, there's an expectation that this employee will get something.
Yeah.
And UIF would not be enough. Now, what I have done with my employees, and please don't take me to Madlanga, instead of complying truthfully with UIF, I take out what we call workers' fund, which is offered by the banks.
Yeah.
Now, the workers' fund it's paid by the employer wholly. The employee doesn't contribute anything. You may say be contributing 300 rand per month. What this covers, it covers funeral for the employer and his spouse and children up to a certain age. And at the same time, it accumulates retirement fee. I have an employee who has just retired. Well, she was lucky because no one died, so she did not get that part of the benefit. But she's going home with over 100,000.
Nice.
Which is something that the family would appreciate. Unlike a UIF, which would be a 6 months payment of peanuts.
Yeah, I think it's a great idea, but it's not an either or. UIF is by law. Yeah, but you said it to a lawyer, so I can't tell anyone.
Some of these obligatory things are just tax. You just have to pay them.
Yeah.
But that's really nice. When I retrenched during my staff thing, I was like, oh, there's a retrenchment package. What's that? You know how much shit I was in. So it was uncomfortable to know that I had to deal with that added financial stress. But for me, the retrenchment or the notice period and the retrenchment package is like, these are things you need to know. If someone has been in your service for a long period of time, when they leave, there's obligations. Can you talk us through that?
Yeah. So If you're a sole practitioner, so you're not an Inc., and you have, say, 5 staff members, and you die, their employment is terminated by your death. If you're an Inc. with several practitioners, and you have employees, and one of the practitioners dies, the employment relationship continues with the Inc. So they may have to be retrenched if they're now surplus to need, and that retrenchment cost would be borne by the Inc. So it's important for you to know, if one of your partners dies, there are potentially implications for the business, unless you bring a new partner in, etc. So I've found that frequently the legal implications of people dying or retiring is often not considered. Many people think that when you retire, you get a retrenchment package. You don't. Retirement is the termination of employment by operation of law by reaching an agreed or normal retirement age. So I say, well, what's a normal retirement age? It depends. In some industries and in some employers it's 60, in some it's 62, and some it's 65. What happens if you let somebody work beyond retirement age? Can you terminate their services afterwards? Until recently, no. Now you can. It's a recent judgment, court judgment. So, and it's highly contentious, but these are things that you have to consider. I think it's a really good idea to bring a financial advisor into your practice to talk to your employees so that they can arrange their own financial affairs, because there is a bit of a patriarchal approach to employment, especially with older employees who think that it's the job of the employer to look after them forever. And it's not. It just isn't. When they're employed in their 20s, they must start doing their own financial planning.
Yeah, I think that's quite tricky because our practices are so small, and then there's this added expectation from employees.
And then the lady at the back. Eh?
Yeah. And wouldn't you say then you can bank on the hope that they will live until they reach the old age pension? So won't you say that to them and say, no, you can just wait for your age to reach that age?
Well, yes, but again, through the filter of kindness, you want your employees to do well. Also, employees sometimes, not always, sometimes go downhill in the last few years before they retire, and you're not obliged to keep somebody on until retirement if they're not performing well. So those are considerations. I think it's really, really important for those expectations to be ironed out up front. I remember chatting to somebody who was involved in I think it was an Anglican minister, and he expected that when he retired, because he'd been employed by the church his whole life, that there would be some kind of plan. And they told him in the year before he retired, sorry, yeah, I hope you've been paying into a pension fund. He said, nobody told me. So those are considerations.
I have 2 questions. Okay, I'll start with the good-hearted one, yeah, Dr. Sater. I did the same, where I took my own money, paid what I called like a provident fund, had a good advisor, I remember it was Sanlam or whatever, put them in, and on top of the UIF. And those were very good employees. But then they got to a time when they stole from me.
Oh dear.
When the person steals and they had to be fired, at CCMA, when I was querying that extra amount that was not part of the law, you were not forced to do it, like he was saying it was either or, CCMA told me that was out of your stupid good heart. Okay, you need to start also, sometimes you employ family and you start thinking very hard,
Yeah.
do within the legal limits and stop there. Invite a financial advisor to advise them on the money you're giving them. So from then on, I changed with the salary I give you. You will pay into Old Mutual or whatever. You will pay for your own pension out of what I pay you. Then I don't have any regrets. Is that what you said? Good. Yeah, they went. Sanlam, whoever, will continue paying them, whether they stole from you or not. They will get their 150,000, walk free, and go. Yeah. So it doesn't help to have a good heart in business.
Well, I'm not sure about that.
Upcoming lawyer. All right, guys. Tasneem, our last question, please.
Yes, so I had a post on Instagram that went a bit accidentally viral because I was talking about commission-based payments in healthcare. And for allied health professionals, it's a very common practice because, allies don't make money and they worry about cash flow. So it's easier to pay your therapist on commission only or with salary with commission. And I attended an HPCSA webinar with the OT Association where the HPCSA lawyer unequivocally said that any commission-based type salaries is not permitted.
I'd be interested to know how he backs that up.
So they said that, and so obviously this causes an uproar. And I said in the post, don't shoot the messenger. I'm just relaying, because I specifically asked this question because it gets asked a lot by allies. I specifically asked this question and said, are commission-based payments allowed? And the lady said no. And I asked, but what rule does it say?
Yeah.
Because you're saying fee sharing is allowed if it's, somebody in your employment. You just can't fee share with someone else. And she said that it's to do with the fact that commission-based payments could incentivize over-servicing. It could be seen as a perverse incentive because if I'm paying my therapist commission on how much they bill, they might be incentivized to charge more codes than what they ethically should because they want to earn more, and that's what the HPCSA wants to avoid. So I just wanted to, so obviously it caused an uproar, so I just wanted to know, a lot of practices are doing this, they're going to do it anyway. How would you, because the HPCSA is so tricky, how would you advise as professions we fight against that, because it really does cause problems with cash flow to run a practice if you can't start out that way.
So I'd want them to show me a provision. That argument could apply to anything. They can't, I would suggest, without showing me a provision that says you can't do this, show me the provision. They can't say just because there's a risk it could happen. Otherwise, there's a risk that could happen advertising your practice because you want to have more people. It's silly. It's a silly argument. Simply the risk that something could happen doesn't mean that there's a rule against it. It means that you have to have measures in place to ensure that it doesn't happen. And there are measures in place. And the measure is you're not allowed to charge for things that are not required. And that's why you have disciplinary action against practitioners who do those things. I don't think that that's an appropriate measure at all. But if you can show me a provision, it's not something I've been asked on specifically, so I haven't researched it. This is not legal advice. I don't think that that's a valid argument.
Well, there aren't any specific provisions. And the problem with the HPCSA, if any of you have ever dealt with it, if you've read their booklets, it is purposefully very vaguely written, by law standards, because it opens to interpretation. And the issue is people get reported to the HPCSA and they can basically twist and turn the words because it's so vague to say, but this is what this means. And my concern is that practitioners are vulnerable then because they, and oftentimes I must just say that it's most often either a member of the public or your competitors who are reporting you. The HPCSA doesn't go and look for people who does wrong things. They sit on their asses and do nothing. Sorry, HPCSA. But generally speaking, it's other professionals. And what happens is if you've got a competitor down the road, and this, I've known cases where a dentist or a doctor reports a colleague because they are jealous of that practice. This is what happens when you say our practitioners are healing. That's what happens. And now you employ your employees all on commission, and then the HPCSA can take into account. But I'm just wondering because this isn't just an HPCS. We're not only regulated by the HPCSA, it's also labor law. It's also, so I'm just wondering if you had to have a client, like let's say I was your client and I said, the HPCSA is now bringing me to account because of I'm employing would from a legal perspective, would there be any clout to kind of bring in all these other things like labor law and to fight the case on behalf of a practitioner?
So, boiling it down to expectations again. The general principle is who alleges must prove. So if anybody wants to say you have breached something, they have to prove that you've breached it. So they have to show in what way is there a rule against this. And I'm just not aware of it. I consulted a couple of weeks ago with the sales director of a business, not medical, different field entirely, and he doesn't earn a salary at all. He only earns commission. But he earns over 500,000 Rand a month in commission. So, and there was a debate between the directors, well, that's unfair because I'm not getting such a high salary, said one of the guys who's paid a basic plus a bit of commission. But he's an accountant. And my answer to that was, yeah, but if he doesn't, if the guy who's earning commission doesn't work, he doesn't eat. You're going to eat whether you work or not. And so there's no legal prohibition against commission. There just isn't. I think it's defensible. Having said that, if you have 3 lawyers, you have 5 opinions, right? But personally, I think it's defensible.
I think when it comes to commission, you must make sure you sit with the accountant, the lawyer, and plan it properly and calculate and make sure the calculation is written down. And obviously then that your standards are, or that you have protocols with your standards. Raymond, thank you very much for spending time with us and for your wisdom. He'll be hanging around a little bit if any of you want to connect with him. A small token of our appreciation.
Oh, thank you very much.
Thank you very much.
Cheers.